So, you've had that aha moment, right? That brilliant idea that you think could honestly change everything. But then comes that big, nagging question. Can I actually patent this? Well, in this explainer, we're going to break down exactly how you can answer that.
It really is like catching lightning in a bottle. You've come up with something amazing. But how do you take that spark and turn it into something you legally own, something that's protected? How do you know if it's truly yours?
Thankfully, U.S. patent law isn't some big secret. It's actually a roadmap, so we're going to walk through it together. We'll start with the big test for patentability, then we'll look at what kinds of things can even be patented in the first place. After that, we'll get into whether your invention is new, this really important grace period for inventors, and then the final hurdle, obviousness.
Okay, let's dive right in. The whole patent process, it really comes down to this one fundamental framework. I want you to think of it kind of like a series of gates that your idea has to pass through to get to the finish line.
And here they are. Let's call them the 3 gates of patentability. First gate, is your idea even the right kind of thing for a patent? Gate 2, is it genuinely totally new? And gate 3, is it a real inventive leap forward? And here's the kicker. You have to pass through all 3. 2 out of 3, not going to cut it.
So let's tackle that very first gate. Before we even think about how new or clever your invention is, we have to ask something more basic. Is this even the kind of thing the law was made to protect? This all comes down to what's called eligible subject matter.
And the law, specifically a part called Section 101, is super clear about this. You can't just go out and patent, say, gravity, or an abstract idea like a mathematical formula. Your invention has to be both new and useful, and it has to fit into one of a few very specific buckets.
And here are those 4 buckets. We're talking about a process, maybe like a new way to manufacture something. A machine, think a brand new type of 3D printer. A manufacturer, which is really just a catch-all for manufactured items, like a new kind of phone grip. Or a composition of matter, like a new drug or a new plastic. If your idea fits in one of these boxes, guess what? You're through gate 1. All right, so your idea is the right type of thing. Fantastic. Now, let's head over to gate 2 and see if it's actually new. This is the novelty test.
Okay, this gate is all about novelty, and to get through it, you have to face what I like to call the great villain of every inventor, prior art. Just think of prior art as, well, the entire universe of public knowledge that existed before you filed your patent. And as you can see from the legal definition here in Section 102, it's not just about other patents. It's scientific papers, products for sale, YouTube demos, anything available to the public that shows your idea was already out there.
Now this is where things get really interesting. On the one hand, as you see on the left, if your invention was already known in any way, that's it. Game over. Gate 2 is closed. But what if you were the one who made it public? Well, that's where U.S. law has this incredibly powerful exception just for inventors.
This exception is so important, it honestly deserves its own section. It's not some tiny loophole, it's a real strategic advantage that every inventor needs to know about.
The magic number I want you to burn into your memory is 1. You get exactly 1 year. From the very first moment you publicly disclose your invention, that could be publishing a paper, giving a talk at a conference, anything, a clock starts ticking. You have exactly 1 year from that date to get your patent application filed.
So let's just walk through how this works. Let's say in January, you publish your research on a new discovery. The second that paper goes public, your 1-year grace period clock starts. You now have until next January to file your application. If you wait any longer, your own research paper becomes prior art that can be used against you, and you could lose your U.S. patent rights forever. It's a huge deal because it gives you time to test things out or get funding without having to stay completely silent.
Okay, so your idea is the right type of thing, and it's brand new to the world. You've passed through 2 gates, but there is one final gate to get through, and honestly, this is often the trickiest one of all. And the whole idea here is summed up in one word: obviousness. See, it's not enough for your invention just to be new or different. The law asks a much tougher question, which comes straight from Section 103. Would your invention have seemed obvious to a regular person with average skills in your field?
And this right here is the million-dollar question. Was your invention a true inventive leap, or was it just the next logical step that anyone in the field would have eventually figured out? For example, if you just take 2 existing things and stick them together in a way that everyone would expect, that's probably obvious. It might be new, but it's not a big enough inventive step to earn a patent.
So, let's just do a quick recap of our 3 gates. Gate 1, eligibility.
from Section 101, is it the right kind of idea? Gate 2, novelty, from Section 102, is it totally new compared to all the prior art out there? And Gate 3, non-obviousness, from Section 103, is it a real inventive leap? You got to get a yes on all three to win the patent prize.
So understanding these three gates, eligibility, novelty, and non-obviousness, it's not just some legal exercise. It's the first, most crucial step in actually protecting your work. It's how you turn a brilliant thought into a real, defensible asset. Now you know the rules of the game, so the only question left is, what will you create?